Supreme Court was back in session today hearing the substantive arguments on a substantive case, the interpretation of Article 97(1)(g) and (h) of the 1992 Constitution. Whether or not upon a true and proper interpretation of this, these four MPs have lost their seats. Joe Gatti led the team.
For Article 97(1)(g) and (h) will only take effect, or will only take effect if the act, that is the person, leaving a party by which was elected to join another party or to remain or to become independent and seeks to remain in parliament without new political coloration.
Attorney General Godfred Yeboah-Dame said the conduct of the Speaker unlawfully and illegally upset the constitutional order of the country.
Insofar as Parliament is constituted by a certain number of MPs or members of Parliament representing those constituencies, the composition of Parliament shall not be altered except as prescribed for in the Constitution. So no person or authority, with all respect, has the power to make any decision at all or construe the Constitution in a way which will alter or change the composition of Parliament except as stated in the Constitution.
The Speaker of Parliament, Alban Bagbin, was not represented in court today. During the entire proceedings, from the start of this case up until now, he has been represented by Mr. Thaddeus Sorry of Sorry at Law, and today there was no representation. The court took due notice of that.
There's nobody here for the Speaker of Parliament. First defendant. All right, by court, no representation for Speaker of Parliament. We note also that the Speaker of Parliament has not filed any statement of case or memorandum of issues, despite the opportunity given for them to be filed. This matter is for hearing this morning. Can we hear counsel for the plaintiff? By court, the judgment of this court will be delivered tomorrow, 12th November 2024. Yeah.
My lords are most grateful.
Lords, we are grateful. Why, I mean, of course, being entirely the prerogative of the first defendant to file anything at all, respectfully, I think that if the first defendant came before the court at last agenda, represented by counsel made representations before the court to file submissions at a certain point in time, elects not to do so, and then for no reason at all, elects also not to appear before the court. Clearly, that is disrespect to the court. I made this observation because I'm the Attorney General, leader of the bar, and all that. Such conduct, with all respect, should not be tolerated by the court.
Leave it to us, Mr. Attorney General. Leave it to us. I would rather advise that as a member of the bar for which you are the leader, you should reach out to him at the close of these proceedings to find out if everything is all right.
My Lord, indeed, my friend, the Chief State Attorney, reached out to him on Friday to find out if processes are done by him. So we've done our bit. Hardly did we expect that he would not even show courtesy to the court by not showing up. Thank you very much.
Honorable Attorney General, I think at the last agenda, if my memory serves me right, you also said, when we asked that you should file processes, he said he had instructions to deal with the matters that he did, and then
he will go for further instructions.
So, if he has not been employed again,
no. But my recollection is that that was before the firm agreement and then statement as to when processes will be filed by the court. That was before it came. But that's fine. That's fine.
We have a lot
to deal with. That's fine. I'm very grateful. Right.
So if we retire early,
right,
because of the public interest in the matter, we should be able to serve the people in whose sovereignty resides.
Precise. I agree. I'm grateful.
The Supreme Court is now expected to deliver its judgment on this raging controversy on Tuesday, 12th November 2024. The court will decide whether or not the declaration of those 4 seats as vacant was in consonance with the 1992 Constitution, or upon a true and proper interpretation, those 4 MPs have truly not lost their seats. This is such a central piece in the current impasse in Parliament, with all eyes now on the 7-member panel presided over by Chief Justice Gertrude Tokono. Reporting for Joy News, Kweku Asante, Supreme Court, Accra.
And from all the actions, it was clear that Mr. Speaker was in the know of whatever they were going to do. So he just called Dr. Atuforsen, and he came out with this thing. We argued it, and unfortunately, Mr. Speaker announced that he was going to give a ruling on Thursday, when he had assured me that he wasn't going to give a ruling, but because of the court process and all that, he was going to wait so that we all abide by the reasoning of the court. Because according to him, the matter was a constitutional matter. So for me, it was a big surprise that Mr. Speaker would go out of his way to make a ruling, which immediately made the NDC proclaim themselves to be majority, although he himself continued to address me as a majority leader. Fast forward, we came to court, the court intervened, and now the new argument of Mr. Speaker was that he didn't give a ruling. He only gave an opinion. He expressed a view on the matter. He met us on Tuesday, the 22nd of October, at a pre-sitting meeting. And at the pre-sitting meeting, I told Mr. Speaker that, well, you are saying you have received the court process and that you have not declared the NDC the majority. Now that they are sitting on our seat, what are you going to do, Mr. Speaker? Mr. Speaker told me that that is the responsibility of the clerk. He later repeated the same thing to the Council of State and the Peace Council. The clerk to Parliament made sure that he had arranged our seat, the majority caucus, our seat, at where we are supposed to sit, the right of Mr. Speaker. Placed our name tags there. The NDC came to remove them. Mr. Speaker was aware of this. He watched and continued with the proceedings, where I think Mr. Speaker failed the nation and failed our democracy. And I do so with utmost respect. Some of the NDC guys are trying to suggest that expressing my view on his conduct amount to disrespect. Let me say it clear that I will be the last person, I repeat, I, Kwamena Afenyo-Markin, will be the last person to disrespect Mr. Speaker. But Mr. Speaker should not think that he's a king. He's an emperor. He's not an emperor. He's a Democrat. Therefore, he shouldn't be too sensitive to divergent views and opposing views. What he's doing, in all humility, is wrong. So my friends in the NDC should open their eyes and ask themselves, if they were the ones at the receiving end, how would they react? The NDC would have raised hell on this matter. But we have been calm in all of these.
Do we have a constitutional crisis on our hands? Do we not? Well, we'll be discussing those salient matters this morning. Today, the Supreme Court, the apex court of the land, will deliver its ruling on that substantive case when it comes to the 4 members of Parliament, whether they retain their seats or not. But the question is, how about the impasse? Will the ruling of the apex court determine what happens in Parliament? Constitutionally, we'll have a guiding light, but what will apply in Parliament? And will the impasse be deflated? Well, joining us for a conversation on same, we have in the studio Roxanne Nelson Dafeamekpor. He is a legislator representing the South Dine constituency. He joins us in the studio. He's also a member of the NDC caucus in Parliament. We also have Dr. John Osai Kwapong. He's a CDD fellow. Doc, good morning.
Good morning to you, Benjamin.
It's a pleasure having you. Thank you so much for joining the conversation. Roxanne, good morning.
Good morning. Good morning to my co-panelist who is not in the studio. And a special morning to my constituents in Pekik, Balik, and to our viewers.
Right.
I'm privileged to be here.
It's good to have you here. Let me start with you, Dr. Dafeamekpor. Looking at how things have evolved, I know we are all expectant to find out what the Apex Court will rule, will decide today. But having got to this point, there are varying schools of thought, including from Chachu Chikata, including from Mr. Ansar Sare, former director of the School of Law, who says this whole thing has no foundation, no basis, no legs, and that the Supreme Court shouldn't have, even initiated this or accepted the suit as filed by Dafeamekpor. Others say no, they are on the right path. Lawyers like Kweku Pinto, among others. What exactly is your understanding of where we are now ahead of the Apex Court's ruling?
Thank you very much, and good morning to Honorable in the studio as well. So, I had hoped that whatever misunderstanding, differences was emerging as a result of this issue, that some way Parliament as an institution would have found a way through its own internal processes to come to some consensus and some political agreement on the way forward. I mean, at the heart of this is what those particular articles of the Constitution mean. When I first read it without, not being a legal or a constitutional expert, I kept saying, especially the phrase that says, if the person intends to remain in Parliament.
Right.
And in my head, I kept wondering, is it the current Parliament that he or she is part of? Is it a future Parliament? Then I listened to the Speaker go through all of the steps in explaining why those seats should be declared vacant, following the precedent of a former Speaker. And then I said, well, if you look at the mischief that the Constitution seeks to cure, it won't make sense that it would apply to a future action, right? That it seems like it's a present mischief that those articles are trying to cure. But then I said, well, let's see how it all plays out. But here we are at an impasse. For me, it looks like at this point, the only resolution, to get Parliament, back is for the court to issue its ruling today on what it means and its implications for what the Speaker had said. Save for that, the only thing I would also add is, for me, and I've been saying this over the last 2 weeks, that I hope in the court's interpretation and ruling that it would find a way to just focus on what those articles mean without also making pronouncements on the actions of the Speaker or the steps and the process that the Speaker took. And I say that
in other words, without antagonizing that arm of government.
Exactly, because Parliament, as they regularly would have said, master of its own rules. It's a co-equal branch of government. It's an independent institution. So I'm hoping that whatever the court does, it would recognize, respect, and preserve that. Otherwise, you run into a territory of the implication of now, does Parliament even need permission or some approval from the court on some of its basic processes? That, for me, continues to be my worry and what I look forward to seeing what the court will do.
I see. And Roxanne Nelson Dafeamekpor is also here. Until recently, I also thought it was pretty clear for me as a student of law, but I guess it's not so clear. So, what is your thinking on how things have proceeded over these last few weeks in respect of the impasse in Parliament?
First of all, let's place this matter in some context. The context is that we are within the 90-day window, which is the Constitution bars the organization of a by-election.
By-election, right.
In the event that a seat becomes vacant in Parliament. I want everybody to appreciate this point so that we can understand exactly what the NPP is doing. Exactly 4 years ago, on the 7th day November 2020, the NPP brought a petition to Parliament and demanded that one of its own members, who had then decided to run as an independent candidate in the then forthcoming general elections to be held on 7th December 2020, to have his seat declared vacant because to them, he had left the party because they sponsored him to Parliament. They got Speaker Michael Okoye to pronounce on this and declare the seat vacant. Andrew Amoako-Isiama never stepped in Parliament until the life of that Parliament came to an end, the 7th Parliament. The NPP then had a majority of 169 members in Parliament. With that declaration, they became 168. A by-election was not held because we're in the 90-day window. Now, sometime in 2022, the NPP again came to Parliament with a request. What was that request? That the Honorable Adwoa Safo had absented herself from more than 15 parliamentary sitting days. And therefore, her seat, that is the Dominic Kwabena seat, should be declared vacant, pursuant to the same Article 97(1) Clause C. Now, under C, there ought to be some inquiry. So when the referral came, well, there were some suggestions from the minority that then it wasn't only Adwoa Safo that the evidence points to the fact that she had absented herself from more than 15.
I mean, there were a number of them whose names came.
So the Honorable Kennedy Ejepong, his name came up. The Honorable Kujeto provided enough evidence to make that case. Then the Honorable Henry Korte. So the three of them were referred to the Privileges Committee. The Privileges Committee went into the matter and made recommendations to plenary. What were the recommendations? That the Honorable Kennedy Ejepong and the Honorable Henry Korte had good reasons, and therefore their seats ought not to be declared vacant. But in the case of the Honorable Adwoa Safo, she failed to appear, and therefore, in fact, the Honorable Joe Osei-Owusu, who is still the chairman of that committee, made the point that it is the mandate of the committee to actually declare the seat vacant. Not even the speaker. This was the argument of the NPP. That the seat of the Honorable Adwoa Safo should be declared vacant by the stroke of pen of the chairman of the Privileges Committee. The speaker said no. That duty was inherent in him as the occupier of the office of the speaker. But as part of the recommendations, or as part of the report, it was revealed that the Honorable Adwoa Safo had not appeared before the committee. So Speaker said, before I would declare the seat vacant, we want to give the Honorable Adwoa Safo the opportunity to be heard, or the alteram partem. So the committee should go back and make the efforts, the reasonable efforts to reach Honorable Adwoa Safo so she can appear and be heard. They said they took all reasonable efforts, but they could not have her served for her to appear. The week after that, the Honorable Adwoa Safo... And
I want you to accelerate a bit because we don't have...
the week after that...
You are setting a precedent or laying the foundation.
I'm pointing to some conduct of the NPP. A week after that, the Honorable Adwoa Safo began to attend Parliament and began to do business with her caucus. So as we speak, that request by the NPP to have Speaker declare Adwoa Safo's seat for absenting herself from more than 15 parliamentary sitting days, pursuant to the same Article 97(1)(c), is pending. Fast forward.
What is the suggestion when you say it is pending. What would you have? You seem to be suggesting something.
Yes.
What are you suggesting?
I'm pointing to a certain conduct of the NPP. It's the same NPP that has come to Speaker to have a seat declared vacant pursuant to the same Article 97(1). Same NPP.
Yes, but now we are looking at different clauses, G and H.
No, it's the same provision. The scenarios painted under the same article are only different. The article says if any of these events occur, a seat must be declared vacant. I hope that the NPP, having gone to court, they are telling the Supreme Court that even though Cynthia Morrison, that we sponsored to Parliament, who is still a sitting member of Parliament, but has decided to go contrary to our own constitution and put herself forward in the Aguna West constituency in the forthcoming parliamentary elections, is no longer a member of our party by virtue of Article 3(9) Clause 1 of our constitution. I hope that's the evidence they put before the Supreme Court.
So
I also hope that...
Let me just take a quick look at 97(1)(c), right?
Yeah.
Or maybe let me just start from A. It says, a member of Parliament shall vacate his seat in Parliament, A, upon a dissolution of Parliament. Of course, once Parliament is dissolved, then we know what happens. Or B, if he is elected as Speaker of Parliament, then you cease to represent that constituency. Or C, if he is absent without the permission in writing of the Speaker, and he here is used generically, so he or she, is unable to offer a reasonable explanation to the Parliamentary Committee on Privileges from 15 sittings of a meeting of Parliament during any period that Parliament has been summoned to meet and continues to meet. And then it goes on, and then you'll have G and H as well.
Yes.
I'm still trying to find the nexus.
The nexus is that this same NPP, which is contesting the Speaker's role in declaring this seat vacant, have an application pending before Speaker, as we speak, to have the Dafeamekpor seat declared vacant by Speaker.
You are saying that if this goes ahead, even if you accept and say these ones should stay in Parliament based on the Apex Court's ruling today, and if Parliament decides to, and maybe I should watch how I'm saying this, because it has appeared that Parliament, as a master of its own rules, can, in some way, enforce its own rules. But the Supreme Court of the land will rule on that matter today. But what you're saying then is that they could win from one angle and lose from another. Is that what you're suggesting?
Because the application is
if the Speaker decides to go ahead and say, okay, so I'm declaring these seats vacant, and there's no possibility of a by-election at this point in time.
Because it's still pending. Because, you see, the conduct for which they complain has already occurred. The only indication given by the Constitution is that the person should provide a reasonable excuse. And the committee has determined that the Adjua has not been able to attend the committee. So there's no provision of a reasonable excuse from
You're
her.
saying that as we sit here now, and I have to go back to Dr. John Osai, but you're saying that as we sit here now,
yes,
I don't know what the processes would be to trigger the declaration, for example, of the Dafeamekpor.
It's only a matter of
vacant.
Yes,
are you saying that at the stroke of a pen, since the processes have been concluded, the Speaker of Parliament could literally say, okay, well, let's go ahead with this.
Because this report is pending.
But based on this report, these seats are now vacant.
Yes.
Is that what you're saying?
Yes, he can do that. Because that happened in the life of this Parliament. And the life of this Parliament has not come to an end.
And will that affect the Henry Quartes, the Adjua Safos, and all of them?
According to the committee, they recommended that their seats should not be pronounced vacant by Speaker. That's the recommendation they brought before.
Is the Speaker bound by that recommendation?
In fact, it's plenary. That decision, again, will be taken by plenary. Because we will debate the report and vote on the contents of the report. And the Speaker will only give effect to what the House would have decided.
Will a decision on this go by simple majority?
Simple majority.
Simple majority.
Simple majority.
Even if it's by one?
Yes, simple majority. The Speaker will just give effect to whatever resolution would have passed.
But let me just say this before I go back to Doc. Some would say that, assuming the Supreme Court rules that, okay, what was done by Professor Michael Quay was wrong. Equally, what was done by Alban Bagbin was wrong. I mean, if they say that this was wrong, it reflects on Professor Michael Quay as well. And so this is the actual meaning. If the Speaker went ahead to do this, or the NDC caucus went ahead to do this, wouldn't it be like Shylock getting his pound of flesh? Wouldn't it be
at all?
You know, what would I say? Vengeance?
No, this is Parliament doing its work.
Why didn't you do that work all this while? Since the committee met, why haven't you done this work? Why do you want to do it? Why do you want to do it now?
Because Speaker directed the chairman of the committee to go back and reconvene and give the Honorable Adjua the opportunity to be heard. And the chairman of the committee is the Honorable Joe Osei-Usu. If he hasn't done that, then that is their problem.
Wow.
Yeah.
Hold for me. Dr. John Osei-Kpor, do you hear what is happening here?
Yes.
This is getting interesting. It's getting turbulent. And if I'm following the trajectory, this could be a long-standing impasse. I mean, what is your reflection on this? Because I thought this matter had died a natural death. But he points to the fact, Roxanne points to the fact that actually it's a live wire. And if we feel this is the way to go, we will go that way. What is your take?
Mm-hmm. You know, and I actually was also thinking, all right, if the Supreme Court makes its ruling on the substantive question today, regardless of how the court comes down, yes, some will be happy, some will not be too happy, but at least it brings conclusion to the matter. But now that I'm listening to the Honorable, and as you've noted, maybe it doesn't really bring conclusion to the matter. I am hoping that it does. And one of the things that I've been reflecting on is I watch our parliamentarians regularly from both sides refer to each other as, you know, my good friend, my good brother, right? Which means that my good sister, my good friend, which means that they, you know, outside of the partisan differences, there is a reservoir of goodwill among them. I'm hoping that at some point they would be able to tap into that reservoir of goodwill and find a way to bring some conclusion to this issue without dragging it any further, so they can also, at least some of the key things that they would like to do between now and when the life of this parliament is over, whether, for example, it's the consideration of the FY25 budget or whether it's some important pieces of legislation that needs to be passed. Hopefully, whatever business the House needs to conduct, they can do that between now and, you know, when the life of this parliament is over. I really hope that there is, you know, a light at the end of the tunnel, and that light is not an oncoming train.
There's something that came to mind, and I'll come back into the studio. I'll come to you in a bit, Doc. Your side, when Sarah Adjua was being lampooned by her own caucus in Parliament, your side came to her defense. Do you remember?
Yeah,
you came to her defense saying that she had rights, she had to be heard, yes, and all of that, right? Which was interesting because she wasn't even a member of your caucus. Yes. Now, you seem to be suggesting that if things go a certain way, you could also trigger the process.
Yes.
And her seat will be declared vacant.
Yes.
Have you turned against Sarah Adjua?
We haven't. You should be asking the NPP why they were interested in getting Adjua kicked out in 2022. Because they would have had opportunity to organize a by-election. EC would have had opportunity to organize a by-election and they would have have her replaced. So it wasn't a problem for them to kick Adjua out at all. So we said, per Article 97(1)(c), the Constitution makes a provision for her to be heard to provide whether or not she had reasonable excuse. It is this provision of reasonable excuse that is holding on to this matter. So if we determine that the party that brought this application is no longer, doesn't appear to be interested, we will trigger it. So
but you talk about
so
legally what we call audi alteram partem. Listen to the other side, giving them a fair hearing, natural justice.
Yes.
How about these four, including the former member of parliament for Amenfi Central, and then the three other NPP MPs? Have they been given a fair hearing?
The Constitution doesn't make any such provision. The Constitution, that provision simply says where there's evidence that they have abandoned their party and seeks to remain in parliament. It is that
have they abandoned their parties?
But they have abandoned your party. If you go to Amenfi Central, the NDC has fielded a fresh candidate, Joanna,
and she's
Joanna Jan.
Been reinstated.
Yes.
By
leave the other court matters, but we have fielded Joanna Jan, and she's running under our symbol and our colours. It is not the sitting member of parliament who is doing that, or the ex-member of parliament who is doing that. So clearly, he's left the NDC, but he seeks to remain in parliament. That's what the Constitution. That is the tail end of the provision people read and don't appreciate. If you resign, then that's all good.
But they have not resigned.
Yes, so they seek to remain in parliament, in this parliament. That is why the speaker will have to declare your seat vacant. In the same way, Cynthia Morrison no longer is sponsored by the NPP in the Aguna West parliamentary race. They have a different candidate.
But she's been standing, if you've noticed, when Afenyo Markin is having his press conferences and the rest, she still caucuses with them.
Standing with them and holding press conferences is no evidence. The evidence is that when we take the notice of poll, you are running as an independent candidate and you seek to remain in parliament. That is what the Constitution says your seat must be declared vacant.
You in Parliament have spoken about precedents. The Speaker himself spoke about Professor Mike Okwe, Aaron Mike Okwe.
Yes.
If we are also to go by that same precedent, and you say Sarah Adwoa-Safo had to be heard, why shouldn't we hear these four?
No, in the Adwoa-Safo, in the provision that they triggered in 97(1)(c), the Constitution makes special provision. It's absent from Parliament for more than 15 sitting days. There has to be an excuse. If there's no reasonable excuse, then your seat will be declared vacant upon the Committee of Privileges making that determination. They will make that recommendation to plenary. Speaker will only pronounce on it. So it is when that pronouncement is done and Adwoa is not satisfied, then she can go to court to seek some interpretation. But where we are now, we will trigger that process. We will trigger that process.
You are threatening.
We are not threatening. We are not threatening. It's only a business.
But you are threatening.
No,
you are saying that if things go a certain way, then we also push.
No, we are saying that there's a business pending before Parliament. It has become critical that Parliament pronounces.
Why now?
Why not now? Why not now?
You could have done this. No. When was this decision of the committee taken?
The life of this Parliament has only 2 months to run, effectively.
2 months? You mean 2 weeks?
Yes. No. In fact, 6 weeks.
Okay, right. I get what you're saying now. You are going into.
So such businesses will have to be determined. It has to be concluded. It cannot be in abeyance for too long. So we'll have to bring it up. The business committee will have to prioritize it. And then the plenary will have to deal with it. 3 members of Parliament, Henry Korte, the Honorable Kennedy Ejepon, and Adwoa-Safo, we have to take a decision on them. It's a matter they themselves brought. The NPP themselves brought this.
Dr. Osankwa-Pong.
Yes, Benjamin.
This, you know that saying, robbing Peter to pay Paul. You take from one end, you give from the other end. This could, I mean, I am befuddled. Not because I am confused, but the whole, the sort of play going on in Parliament, and I use play respectfully, not in a,
in context.
But the political game being played in Parliament. So let's say that today, let's assume today the court rules that okay, the position of Mike Okwe and given strength by Alban Bagbin are incorrect. Then his side also says, okay, we are now going to trigger for this other bit to be followed through. Adwoa-Safo, Henry Korte, and who was the last one? Kennedy Ejepon. So that they vacate their seats, which would still create another 3 losses for the ruling administration. Do you think that's the way to go? Let me just put a pointed question to you.
With all due respect, I will say no. I will say no because, in principle, I can understand why the Honorable would say, look, it's parliamentary business, we have to conclude on the matter. But if you put it within the context of the continued, back and forth on this issue, it drags this even further, and for me, it creates an impression or a public perception that, we can't find some points of agreement within, the Honorable House. I'm not a big fan of politics that starts becoming too adversarial in nature, right? That at some point, I just hope for a consensus on certain matters to say, you know what, we've quote unquote fought about this long enough that we've reached a point where we can put a stop to the fight and move on past whatever impasse it has put us in. So I would hope that it really doesn't come to that. I would hope that whatever the court decides, and I have no reason to believe that it won't be respected. But what if the court also comes down and says, former speaker was right, current speaker is right? Let's just assume that is also a possibility. Then what does the NPP side do? Do they go back to the court to seek a review of that? Do you see what I'm saying? I mean, at some point, hopefully, we can appeal to the better angels in each of us and say, look, let's end this matter, and let's move on.
So it appears there's some political tit for tat, a refusal to bend from all sides. And if the Dafeamekpor seat, together with the others, if they are subjected to what you are talking about, what will that mean for the majoritarian status in Parliament?
He's further deteriorated, he further tilted towards the NDC. Now, you see, you let people understand that what's happening is symptomatic of the issues of indiscipline that has bedeviled the NPP. It's about indiscipline. Because the application that I speak of was brought under Che's leadership when Che was the majority. Yes, when he was majority leader. They
which specify which?
That is the request that Adwoa Safo's seat be declared vacant.
Okay.
Because she decided to abandon the caucus for over 6 months. It became a topical issue in this country. Even her ministerial roles she was not playing. She was then based in the US. Then we found 2 other pieces of evidence. Again, in respect of 2 other members of the NPP, and added them to Adwoa Safo, and they were referred to the committee. Work had been done, report prepared, reports on hold. Now, 2 of your members have decided to jump ship, to go AWOL, to run as independent candidates in their respective constituencies. Now, I heard Attorney General yesterday that nobody has power to tilt the composition in Parliament. But they got the Supreme Court to tilt the composition in Parliament. If nobody has power to tilt the composition in Parliament, has the Supreme Court got power to tilt the composition in Parliament?
The Supreme Court has been called upon to give interpretation.
Exactly.
Has it not?
But as part of his submission, he practically took the Speaker to cleaners and said all manner of things about the Speaker.
He says the Speaker should realize he is not a king. He's not an emperor. He's
no,
a Democrat.
that's about Afenyo. But I speak of the Attorney General on the belly when he was on the.
Oh, you're referring to
the Supreme Court. Yes.
Right.
All right. And I think that and I keep saying that the Attorney General, with all due respect, doesn't appreciate how Parliament works, because it's the same Speaker who tilted the balance of power in Parliament. It's the same Speaker who read a letter, a mere letter from the Formina MP, independent member of Parliament, that I will caucus with the NPP. Because if you recall, the House was split into 2 equal halves. 137, 137, 20 females on each side. All right? Now, with a letter from the Formina MP, Speaker proceeded to declare the NPP caucus as the majority. And by that, you got to elect the majority leader of the House. You got to chair over 85% of committees of parliament. And with vice chairman and chairman, with all the benefits that comes with it.
Okay, hold for me briefly.
So,
hold for me. I'll come right back to you. Let me cross over to the forecourt of the Apex Court, actually, because, well, they are actually in the chamber currently, and Kweku Asante is also standing by. But let's bring you some footage from the Supreme Court currently. So you would see some lawyers there already beginning to have some discussions. And this is exactly where the Supreme Court is going to sit this morning, as they have done in the past, and they will be delivering their ruling on that impasse in Parliament. Kweku, if you can hear me, what can you report from the Apex Court this morning? Can you hear me, Kweku Asante?
Straightforward, they're about to issue their judgment as regards to the interpretation of the launch. The day the court heard a substantive from Joe Dash, who is lawyer, for Alexander Market, leading the past legal team, that he put someone attached who you see the results. There was Super Kwesi was part of the team. He also took the shot, and then there was their turn.
Well, it doesn't appear that we can we have the connection to Kweku Asante. Kweku, if you can hear me, just let's try to reconnect, and then we shall come to you. I see Atachia in court there as well. We'll try to reconnect with Kweku Asante in court. But let's come back into the studio now. Roxanne Nelson, Dafeamekpor, you were making a point.
Yes.
I'm sorry I had to truncate
It's fine. So my point is that it took the same speaker to determine the composition of parliament in favor of the NPP. The Attorney General soon after became an Attorney General. All right? He didn't see anything wrong with it because it benefited his party, benefited his caucus in parliament. And today he stands in the Supreme Court and says that nobody has the power. It's only the Constitution that will trigger that. So when the constitutional provision is triggered, he could say that he disagrees with the interpretation, but he can't say that nobody has the power. When the provision is triggered, it is triggered. Is he saying that when, for instance, a member of parliament dies, we should go to Supreme Court to seek interpretation as to whether or not the seat of the member who has died should be declared vacant? Because the Constitution is very clear that when you die, your seat is declared vacant. And who does the declaration? It is the Speaker. It is the Speaker who is mandated under the Constitution to write to the EC announcing the vacancy, based upon which the EC will proceed to organize the by-elections. All the by-elections we've had as a result of the death of the substantive members of Parliament. Was it not the Speaker that declared the seats vacant and subsequently wrote to the EC to have the EC organize by-elections? So this attitude of at the slightest opportunity, they take an infra dig at the Speaker, both in the courtrooms, open courtrooms, and in the media, is unacceptable. Afenyo Maki actually goes to court and deposed to affidavit and says that what Speaker did amounted to a coup d'etat. And I keep saying that the Supreme Court agrees to such use of language. They didn't find it scandalous enough to have that portion of the affidavit struck out. How do you say things like that under oath before the highest court of the land?
Do you feel these personalities, Afenyo Markin, the Attorney General Godfred Dame, have disrespected the Speaker of Parliament?
Time without number. time with that number. At the least opportunity, they go after the speaker.
Let me ask you.
And nobody speaks for the speaker, so they always have a field day.
Well, the speaker at least had his press conference on the 6th day of this month. But
Yeah,
hold.
because you don't find that as unusual.
Right. Let me also ask you,
Yeah.
has the speaker also been disrespectful towards, at least, let me say, Dafeamekpor? You remember Dafeamekpor talking about the fact that he had been to the house of the speaker on numerous occasions, trying to get him to Georgia on the matter and all of that. And the suggestion is that the speaker was simply not willing to engage him.
I will find that extremely unbelievable. Because the leader of parliament, which is the leader of the house, and the speaker have such a cordial relationship that without that, there's no way parliament will function. Now, Dafeamekpor, having become who he is as the leader of the NPP caucus, still has the speaker's ear and audience. And what I find offensive and quite unethical is the penchant on the part of the Honorable Dafeamekpor to always run to the media and say that I met the speaker in camera, I met the speaker in chambers, and we had ABCD discussions. In-camera discussions, chamber discussions are not for public consumption. You can speak to matters that happens on the floor and take them to the media. But when you leadership, you go to speaker in chambers, you agree on certain things. Even me as a member of parliament, I'm not supposed to hear. It's on need to know basis. So how will the speaker have confidence in you to keep discussing matters with you in confidence?
Are you suggesting parliamentarily such behavior is unethical on the part
It's unparliamentary. It's unparliamentary. Because when you come to me in chambers, we hold discussions and you are in the media, whether it's true or not, you are broadcasting them. Why would you want to come to me in my home and come and hold any discussion?
On this point...
Even if the point Dafeamekpor makes is accurate, if I were the speaker, I would have done the same. I will reject you. If you want to meet me, come to me in the office.
Okay. On this point of disrespect, again, yesterday in court, the speaker did not have representation. Thaddeus Sori and the junior lawyers from his firm, Sori at Law, were nowhere to be found. The AG brought up the issue that signaled disrespect for the apex court, which some justices, two of them, also reacted to, and that was not, there was no proceeding on that. How do you feel about that?
I feel sad. The AG always has this attitude of inciting the court against other lawyers, or inciting the General Legal Counsel against other lawyers who hold contrary views.
I think it's Justice Mariama who...
He did that just last week when he went to give some lecture and practically was engendering the General Legal Counsel to proceed against some lawyers. Then you go to court as the leader of the bar and suggest that a lawyer for speaker failed to appear and therefore it amounted to disrespect, when he knows that lawyers will act upon instructions. Who knows that since the appearance of Senior Thaddeus Sori in court the last time, maybe the speaker has instructed that please don't go again. Maybe.
Some say, in fact, that the speaker shouldn't even have been joined to this suit, and that maybe the AG, in fact, should be represented.
Indeed. So if the speaker has withdrawn his instructions to Thaddeus, what would Thaddeus be doing in court?
But the point too is, why start the process and then, I wouldn't say surreptitiously, but abruptly disengage, especially when you started appearing before the apex?
This whole process is an abrupt one.
No, but I'm asking,
why
start and then not
this whole process is an abrupt one, if you can appreciate it that way. So speaker's presence or non-presence in court, his representation in court or not, I think the Attorney General ought to have kept quiet after making his submissions. But again, he was inciting the court to perhaps give some orders directed at Thaddeus Sori. And the court saw through it. The court was trying to give him a guide, but he was insistent until another judge had to join in. That no, they leave that matter for us. Why are you trying to incite us against another lawyer? Leave that for us. So they advised him that as the leader of the bar, call your colleague and find out why he didn't appear in court.
And he said that, in fact, on Friday or so, they had checked on whether processes had been filed by Thaddeus Sori.
Yes. So why didn't he precede his submission with that? Before making those scandalous comments about the lawyer. So it goes to his motive for which he was making those submissions before the court. Very, very unethical conduct. But hey, he is the AG. I am not. So.
But well, even the AG has to work within a certain remit.
Thank you.
Right? And I'm not suggesting anything by saying that, but the way you sounded, he's the AG and you are not. It shouldn't also sound as though the AG were, because there's no primus inter pares as far as our legal system is concerned.
But he
even the president.
No, he is. No, in terms of practice at the bar, he's the primus inter pares.
No,
That is why
he is the head.
Yes.
Of
no, but
the
I
bar.
speak. Now we are speaking of matters at the bar.
Okay.
So I'm saying that at the
we
bar.
are speaking specifically within the bar.
Yes. So at the bar is the primus inter pares. That is why when you go to court for 2 hours and you are waiting patiently for your matter to be called, as soon as the AG comes, his case will be called.
Okay. I was speaking generally in terms of the law applying.
Yes. As for that
everybody.
one, that's equality before the law. Yeah.
Dr. Osai-Kwapong, I forecast, I see that this matter is not dying anytime soon, unfortunately, because I don't know, maybe at the very start of this, maybe whether the approach, because you see, there are those who have said that perhaps if, and I say this respectfully, without demeaning Alexander Afenyo-Markin, but there are those, even from the NDC side, who have spoken to me and said that, listen, if Osei Mensah Bonsu were to be the majority leader, we wouldn't be where we are now. And when Evans Mensah spoke to him, he also suggested, and I'm talking about Osei Mensah Bonsu, the former majority leader, how different perhaps his approach would have been. Just hold for me before, are you of the same opinion? That perhaps under Mensah Bonsu,
you see, to the extent
he wouldn't have gone the way Alexander Afenyo-Markin has gone.
Che, and I know if I say this, Afenyo will not be happy. But I think that Che would have approached this matter quite differently with a much better results. Because Che knows that he has an application pending before Speaker in respect of the status of 3 members of his caucus, in respect of the same provision of the Constitution. So these are political issues you will resolve politically, amicably. The judicial resolution of this matter won't yield any fruits. The judiciary can resolve this. All right? So Che's approach, with all due respect, given the litany of instances I have witnessed over the past 2 weeks, I am minded to agree with those who think that his approach would have been different, with a better outcome.
Doc, like I was saying earlier, I don't foresee, especially with the new dimension, the new dynamic that has been introduced into this conversation, where the NDC could also trigger those processes and then have those 3 members of parliament who are still in parliament.
They've forgotten that is pending, clearly.
And that could be dealt with by the Speaker on a simple majority vote, and that could also lead to some seats being lost. Do you see any end to this?
I don't. As I mentioned earlier, I was hoping that the end of this matter would come once the court makes its pronunciation and everyone expresses, their disagreement or agreement with the decision, but it quote unquote settles the matter, and we get back to life as we knew it before all of this started. But again, from what Honorable is saying, it appears that depending on what happens to court today, that pending matter from 2 years ago would be resurrected, or at least there will be some call for that to be acted upon.
But it will still depend on who can muster a majority number in Parliament to determine whether or not this will become a major issue.
Right. And the other thing that I've also been asking myself, and again, this is with all due respect to the institution of Parliament and the actors in there, but one of the things I've been asking myself is, if control of Parliament were not at stake, will this matter have generated the kind of, do you see what I'm saying? That if the Speaker had declared those 4 seats vacant, and it didn't alter the composition of Parliament, where the majority still remained Parliament and the minority still remained minority, it wouldn't have resulted, in my opinion, in this impasse that we see. But because it altered the change of the control of the House, is what I believe has fueled this.
Dafeamekpor says he will never sit in the seat of the minority leader because spiritually it is wrong. I found that one interesting. What's your reaction to that?
Well, the late J.S. Mbiti always used to say that the African is notoriously religious, right? That everything has a spiritual and religious meaning
Is this religion or superstition?
All of it. And that's Mbiti's point, that for the African, even if I came into your studio and I sneezed, it wouldn't be an ordinary sneeze. It would have some spiritual, superstitious meaning to it. So when I read the comment, I said, this is, this is just the interplay of religion and politics and superstition, right? That what if I go and sit there and my party loses? But again, it's one of those things that comes with the territory of politics.
I see. Coming back to you, you also filed a process trying to stay the hand of the Speaker in any subsequent actions. What's the status of that?
It's a fresh matter pursuant to Article 99 of the Constitution. So I'm before the High Court.
Because today, of course, 99 of the Constitution will take you to the High Court.
Yes.
It's stated categorically there, which some of you have said should have been the case in this instance. But today, why I pose that question, today the court is ruling on that substantive matter, the declaration of this 4 seats vacant. You were trying to stay the hands of the Speaker. Today, the Apex Court is declaring on this matter. How do you proceed with the High Court when the Apex Court is deciding?
I think the Supreme Court has no power to take the constitutional jurisdiction of the High Court away. They cannot do that.
But in the end, the buck stops with them, doesn't it?
Yes, they cannot do that.
In terms of interpreting the Constitution.
Yes. The interpretation is different from assertion. That's bringing your right to life or invoking the original jurisdiction of the court in this matter. The Supreme Court says, the Constitution says go to the High Court. It can travel all the way to the Supreme Court if an aggrieved party decides to proceed to the court higher up. But for me, the forum convenience to initiate any proceedings on this matter is the High Court. And that's what I've done. So, but let me make the point.
So briefly,
let me make the point that Dafeamekpor saying that on grounds of spirituality, he won't occupy the minority leader's seat is an afterthought. Because he had already taken an oath and sworn to affidavits before the Supreme Court and made the point clearly that the NDC minority had become the majority, which by that deposition makes Atuforsen eligible to sit in the majority leader's seat. So by your own words on oath, you have declared yourself.
How did he do that?
Did you check his affidavit in support of the expert application before the
Supreme Court? That's what you're... No, I just wanted to...
Exactly.
That's what you're referring to.
Yes, he has gone to the Supreme Court to say that the NDC minority had now become the majority in Parliament. And he, the majority, had now become the minority. And listed a lot of things that the new majority caucus in Parliament can do including holding parliamentary inquiries, including making his government unpopular.
I now get where you're going.
Yes. Right. So, by your own words, you have declared yourself a minority leader. So, the seat is meant for you. This spirituality thing is an afterthought.
All right.
He will come and occupy it. He should come and do his business.
He will come and occupy the minority.
He will come. Come and occupy it.
He says spiritually it won't work.
From 2025 to he will occupy it. That is if his party retains him as minority leader.
Dr. John Osai-Kwapo, your final words. This battle, I think I'll have to recuse myself. I'll leave the elephants to do it. I will not be grass. So, any final thoughts?
Yes, well, I think I would go back and repeat what I said in the beginning, which is I still believe that the honorables do have various amounts, levels of goodwill for each other. And so despite all of the, what appears to be a lot of acrimony and differences, sometimes sharpened rhetoric from the Honorable Afenyo-Markin, which I believe hasn't also been helpful to the situation, that when all is said and done, they really will tap into that reservoir of goodwill and say, look, there's a way out of this. Let's end it all and let's just continue with the business of the House.
All right. This is where I don't believe there's anything else. You said
my final words are that when next we go to Parliament, the Adjua-Safo process, Kennedy Ejapon process, Henry Kotte process will be triggered.
All right, thank you. Thank you very much.
We are putting them on.
Let me now go to Kweku Asante, who is standing by from the Supreme Court. Kweku, if you can hear me, what can you report from there?
Yes, so we expect that pretty shortly the Supreme Court will go into session. I've seen some of the staff of the judges who have already come to move the seats of the judges a bit backwards. That is what is done in anticipation of the arrival of the judges. Already in the courtroom, you can see a number of judges have already taken their seats. The Deputy Attorney General, in the presence of Diana Sunabadapa and Alfred Chimekpor, as well as some senior state attorneys, have already taken their seats. Samuel Atatia, a member of the legal team of Alexander Afenyo-Markin has come in. I just seen Frank Anodom, the majority chief whip. He's also in now, together with other members of the members of parliament from the NPP side. So a number of NPP MPs are now coming, taking their seats. Members of parliament, we expect that a lot of them will come in today, given that today is the verdict that the Supreme Court is expected to deliver as to whether or not the Speaker of Parliament was constitutionally empowered to declare those 4 seats as vacant the way he did on the 18th of October. That is about close to a month ago. This is the day we get to find out if that was constitutional or not. The Supreme Court have heard arguments already. We have concluded all the hearings. The day is verdict. As soon as that comes, all we expect the case will call and they will discuss. They will the judge that delivered the chief that decided that is at hearing that.
Kweku, we are losing you a bit. Could you reposition yourself and start from about 15 seconds ago?
And then these are the signals that and we get ready.
Well, at least snippets of what we got from Kweku Asante reporting from the Apex Court there. And those are some visuals from the Apex Court. A deputy AG seated there, Madam Asunaba. We do not have any view of Alfred Yeboah or Godfred Yeboah Dame, but this is where the chips have fallen. And this is how we are waiting to see what happens. Oh, yeah, that is Alfred Yeboah. I now see him. There he is. And yesterday we saw that he started, and then later Godfred Yeboah Dame, the AG, came through. And you can also see the Member of Parliament for Old Tafo also seated there And then you have Frank Anodompre also sitting there, and all of them, having that conversation ahead of, the justices of the Supreme Court taking their seats to proceed with the matter. Well, we are taking a breather here, and when we return, when there's some action from there, we'll cross over. But for now, this is where we hang our boots on this conversation. Those who joined us, Dr. John Osai Kwapong, he's a CDD fellow, and Roxanne Nelson Dafeamekpor, he is legislator for South Dine. Gentlemen, thank you so much for joining the conversation. We're taking a breather. We'll be right back.